Welcome to SQE1 window, another lecture or discussion. I won't call it lecture. Lecture is a bit boring. We'll try to discuss the topic of defending a claim. Since the claim is started, we need to defend it, and we will try to just give you a horizontal understanding of how to defend a claim. To start with, this is the moment where the defendant, often still recovering from the shock of receiving a rather unfriendly letter of claim, has to act fast. The time starts. Now, under the pre-action protocol and the practice direction on pre-action conduct, the defendant cannot just hide behind the sofa hoping it will go away. They must respond within the time limit, usually 14 days from an acknowledgement, 28 days for a full response, and decide whether to admit, deny, or politely say, I need more time to think. Remember, failure to respond reasonably can lead to cost sanction. And no one wants to explain to a client why they have to pay the other side's bill just for ignoring the post. So think of this stage as damage control, a chance to narrow dispute and maybe even settle before things turn otherwise or difficult. So the first thing is letter of response. This is the defendant's formal reply to claimant's allegation. It should never be a rant. It must address the issue clearly. Don't be emotional and don't say that I don't admit anything in it. So if there is something admissible, admit. If there is something that you think you need to deny, deny it. Or explain what is still under investigation if you are trying to investigate it at that point. If the defendant admits liability or causation, the admission can become binding. So, especially for claims under £25,000, unless it is properly withdrawn under CPR 14.1a. So no casual admissions like, yes, probably my fault, unless you truly mean it that you can compensate and you will compensate. The letter should also show willingness to explore ADR. It keeps the court happy and may save a few £1,000s in cost. Remember, tone matters. A well-drafted letter of response look professional, measured, and strategic, not emotional that why the claim came against me. This is law, not Love Island where you are to perform. So, denial of claim and use of experts, very important. So now if the defendant denies the claim, they must do so properly. It is not enough to just say, I disagree. You need to say why you disagree. So under CPR 16.5, that expects clear reason that why you disagree. Is the issue about liability, causation, or quantum? Explain it properly. If expert evidence is needed, say an engineer, doctor, or surveyor, corporate, or at that point, you need someone to look into that issue. So cooperation is the key at that point. Joint experts are preferred before proceeding. Courts hate parties who go rogue with private experts. So if you are defending a case about a dodgy building extension, do not just bring in your uncle or someone who once built a shed and claims an expert. Make sure your expert is qualified and impartial. This can make or break credibility later in the court. So that's what you need to keep in mind. That someone who lives in our street claims as financial expertise and all, and they don't know they are YouTuber experts at some point. So don't hire them for a serious work. So responding to a claim. So that's very, very important. So now once responding land, usually by post or email sometime, ruining a perfect good morning, the CPR deadline kick in. So the defendant has 14 days from deemed service to respond. The options are admit to the claim, acknowledge service, which buys you another 14 days or file a defense straight away. Acknowledging service is like saying, yes, I'm here, I just need more time to prepare my argument, but fail to do either, and the claimant can get judgment in default faster than you can say CPR 12. So once you keep silent, you don't respond. Say the possible thing is judgment in default in the favor of claimant. Always remember to just keep track of all deadlines properly. In real practice, missing one could mean your client owes thousands without even getting to tell their side of the story at that point. So, filing the defense. Onto the defense, CPR 15 and PD 15 are your guide here. Practice direction 15. The defense must be filed at the same court as the claim within 14 days or 28 if you have acknowledged the service. You can even agree a further extension of up to 28 days under CPR 15.5, but make sure it is confirmed in writing. Courts, they love clarity if you get everything black and white. Each allegation must be admitted, denied with reason, or put to proof. Avoid blanket denials. They are as helpful as saying, I disagree with everything. Judges do not like it, and it can make you look unprepared. Strategically, this is where you build your story. Every sentence should make the claimant's case look shakier, while keeping your client's version consistent. Think of it as a polite but firm game of chess, not checkers. So, additional claims under CPR Part 20. Now, this is where it gets interesting. Additional claims, for example, you need to claim something additional in that case. So, this Part 20 lets defendant bring counterclaim, contribution claim, or indemnity claim. In plain English, this means if you are being sued, you can sue right back or drag someone else into mess, that it was not only me, someone else was also involved in it. For example, if you are a builder being sued by a homeowner, but the real problem was your supplier's faulty material, you might bring a contribution claim against them. You can file a counterclaim against the claimant without permission, but if you want to add a third party, you will need the court's blessings or permission. Timing is crucial. Usually you must do this when you file your defense or within 28 days of another party's defense. So yes, the defendant's table can get crowded quickly. Claimant, co-defendant, and third parties all arguing, but if done right, it keeps everything in one place and saves a fortune in separate proceedings. So, procedure and service of additional claim. Sorry, the font is very small. Forgive me for that. So when it comes to serving these extra claim, think precision. The rules are not forgiving. If you serve late or without proper document, it can delay the whole case or even invalidate your claim. So counterclaim are usually served alongside the defense, but if permission is needed, it is new claim form with all the trimmings, particulars, statement of truth, and evidence. Always include response form and copies of all pleadings. In other words, give the other side a full paper trail. Remember, in civil procedure, organization is your best friend, and the courts too. And yes, the court does notice when you send things in an orderly way. Judge love tidy bundles almost as much as they love punctual solicitors. So reply and defense to the claim, how to reply and how to defend when the claimant receives a defense with a counter claim attached. It is not over yet. The claimant can file a reply to address new point. And if there is a counterclaim, a defense to counterclaim, This must be done within 14 days of service unless the court says otherwise. The reply is not a chance to fix a weak particulars of claim. It should only answer new issues which are raised by defendant. Missing this deadline can lead to default judgment or the counterclaim, which is not a good look. Always remember, time limits in civil litigation are not suggestion, they are deadlines written in stone, or at least in CPR font size 12. My font size is not good today. Sorry for that. Once again. So calculating time and practical points, that's what is tested most of the times. Now a quick reality check. Time calculation, it seems dull, but it is one of the most common SQE traps. Count clear days. Do not include a starting day or the day of the event. If the period is 5 days or fewer, ignore weekend and bank holidays. If a deadline falls on a day the court is closed, roll it over to the next business day. Quick example, if particular of claims are served on 2nd of October, the defense is due on 16th of October. Get that wrong in the exam and you are toast. In real life, diary management serves career. Missing a deadline can cost your firm a client or worse, professional embarrassment. Always double check your calendar and never trust Outlook to do the math for you. So the last thing, our favorite for SQE pitfalls and all. Finally, let's talk about exam. The SQE loves time limit and procedural trap. Watch out for the difference between filing and acknowledgement of service in defense. Remember CPR 15.5, if you extend time by agreement, you must notify the court or the extension is invalid. Do not lose marks over paperwork. And always identify the stages of process. Are we still pre-action or has the claim been issued? That determines which CPR rules apply. You don't need to worry, they don't test most of the time the specifics about the rules. The golden rule, never assume ADR is optional. Court expects you to consider it seriously, and party who refuses it unreasonably can get walloped with cost sanctions. So in your SQE1, think like a practical solicitor. Know your deadlines, be strategic, and never forget the civil procedure rules. And I wish you all the best. For more information, once again, I would request you to get our notes and question banks to prepare effectively. Thank you. Ta-da!